Hey, come here. Let me tell you something. 91% of you all watching my videos aren't subscribed. Hit that subscribe button, like this video to get this generational wealth transferred to your family's royal estate. Federal rights versus state rights, clarified. While the 14th Amendment doesn't protect all your rights. In Jones versus Temmer, the Supreme Court clarified a subtle but critical distinction. The 14th Amendment's Privileges and Immunities Clause protects federal citizenship rights, not all rights granted by your state. Most people assume the 14th Amendment is a universal shield for all their rights. It's not. In Jones versus Temmer, the court explained that the Privileges and Immunities Clause is narrow in scope. It does not incorporate the Bill of Rights to the states. It does not automatically protect every right you enjoy as a state citizen. Instead, it protects only those rights that are peculiar to being a citizen of the United States. Federal citizenship, not state citizenship. This distinction matters if you're asserting claims or seeking remedies. Knowing which rights are federally protected versus state defined can make or break your standing in a court. When the court decided Jones versus Temmer, it drew a quiet but powerful boundary, one that most people still blur to this day. The 14th Amendment wasn't written to guard every right under the sun. It was written to protect a very specific kind of citizenship, federal citizenship. It reaches only those privileges that come from membership in the Union itself, the ability to cross state lines without interference, to petition the federal courts, and to receive protection under national law. But the rights you exercise as a citizen of your state, the ones that govern your property, your domestic life, your civil freedoms, those arise from your state constitution, not from D.C. And here's the catch. When you stand in the wrong capacity, when you assert a state right under a federal remedy, the court cannot see you. Such rights aren't cognizable in a court of equity, or actually in their court of war powers. So your standing collapses. That's why old judges spoke so carefully about capacity and character, because in law, the flag under which you speak determines the voice the court hears. From an equity vantage point, that's more than procedural detail. It's jurisdictional science. Equity teaches you how to know the difference between the two realms, the public law of the Union and the private law of conscience. And until you learn to separate them, you'll never stand firmly in either. So what do you do with this? You study the boundaries until they vanish, not by ignorance, but by mastery. Beyond the federal and the state sits the exclusive jurisdiction of equity, the place where rights are not granted, but recognized. The 14th Amendment can protect your privileges as a U.S. citizen, and your state can guard, will guard, shall guard your local rights. But equity, or let me take out that shall, your state can guard your local rights. But equity governs the space where both meet, where trust replaces all the politics and your authority flows not from statute but from standing. This is why heirs and beneficiaries study the private side of law. We study the private side of law. We love the private side of law. They learn, we have learned which form to speak in, which jurisdiction to invoke, and which capacity to appear under. They stop mistaking access for ownership. And once they do, remedies that once seemed impossible begin to unfold naturally. Because in the end, every constitution, federal or state, bows to the same sovereign principle, conscience. And the one who knows how to navigate both realms, law and equity, form and spirit, is no longer a petitioner. He or she is a ruler.